Thank you very much. My name is James Githa Kanginya. Uh, by exam preparation founder, which have three components. By exam preparation website, which have researched past papers from 2008 on the website. I do online classes so that to create content for my YouTube channel, and I also teach people physically if provided in my on my availability and the student how affordability of the student. Yeah. So now we are on professional ethics. Let's start with prayers. Father, we thank you for giving me yet another opportunity to conduct this class. Thank you, God, for the participant, for the subscribers you have given me views. I did take it for granted. I pray God for the participant of today's class, Mr. Osanu Wakiaga. Bless him, the stamina, give him stamina to attend all these classes, and giving him opportunity to be able, God, to do these classes with him for the online classes. Bless us. Bless him as he prepare for the subject he's doing in April. Favorable questions during the day, good health, and after the exams in May, we pray, God, that you are going to get good results. Bless the work of his hands. When the results are out in May, we pray, God, for his passing and later admission to the advocate this year. We pray all this believing in Jesus Christ, our Lord and Savior.
Amen.
So today we are in professional ethics. We are on October 2022. We are going to deal with question 1, 2, and 3. Yeah. So generally, professional ethics is one of the most failed subjects. That's why I am creating content ahead of April 2025 exams. And if you want to pass this subject called professional ethics, is divided in 3 parts. Number 1 is pre-advocate, pre-becoming an advocate. So the questions that comes from there are on your on Kenya School of Law and ATP program. So you need to familiarize yourself with the Kenya School of Law Act and the regulation, and the Council for Legal Education Act and any regulations. Then that one is like 10%. Then 80%, majority of the questions come from when you become an advocate, ethical conduct and practice. So that's why it's called professional ethics and practice. So you need first of all to know the Advocates Act, SOPEC, Standard of Professional and Ethical Conduct 2017. Those are the two main things. Advocates regulations and Royal Society of Kenya Act and regulation, especially on practice matters. Then the other 10% is advocates who join other professionals, state councils. Like today, we are going to deal with a question on state council, prosecutors, county attorneys, legal officers in public service, in-house lawyers, such kind of things. So you need to know the Public Officers Ethics Act, the Constitution. You need to know the code of conduct for state prosecutors, state councils, for prosecutors, state council, the relevant act that governs those officers, like the Office of Attorney General Act, Office of Director of Public Prosecution Act, County Government Acts on county attorneys, and any other, even the lecturers, advocates who become lecturers, You need to know the law that govern them, even the Employment Act. Yeah. So that is like 10%. If you do that, you are going, you look at the past papers, another very, very important. 3 out of 6 questions in the exams come from past papers, directly or indirectly. And when I'm doing these classes, I usually refer to the question when it was tested last, going backward. On the website, I have researched year 2008 to 2019 professional ethics Q&A, June 2021. So video starts from November 2021, April 2022, and now we are in October. We are going to go all the way to April 2024. And it will be going to be a very good journey. So I welcome you for this subject. And I'm now going to read this paper, the October 2022, had best and worst performing answers. Yeah, CRE list. So we are going to look also at the answer of the best and past performing student. We build on it, we criticize it, yeah, to make it better. So I'm going to read question 1, October 2022, which is projecting on your screen. And question 1, of course, is compulsory and usually carries 20 marks. Yeah. So Okundo was sued for trespass into the parcel of land in which he resides with his family. He promptly instructed Kwaleso, the managing partner of a firm of J. Kwaweso and associate advocates, to act in him in the matter. Okundo was subsequently served as with an interim order requiring him not to trespass or enter into the disputed land pending the hearing determination of the case. The order amounted to being evicted from his premises, where he resides with his family, before the relevant evidence have been presented and evaluated in court. The interim order was issued after Kwaweso failed to inform Okuda. So every time you are reading professional ethics, underline the ethical issues, the practice issues. Yeah, in an exam. So we are going to go underlining as we find them. So the interim order was issued after Kwaweso failed to inform Okuda of the application for interim relief by the plaintiff or even respond to the application. So one of the things the advocate Kwaleso failed to inform Okuda of the application for interim relief by the plaintiff or even respond to that application. So you underline that. Upon being served with the order, Okuda promptly headed to the farm. The reception informed Okuda that Kwaleso was away and he would wait for about an hour. He tried to call the advocate, who neither picked the phone call nor called back. That's another thing. The advocate never tried, he tried to call the advocate, who neither picked phone call or called back. That is an ethical issue. He had actually been constantly trying to call Kwaleso on previous 2 days without his cause picked or advocate calling back. Another ethical issue. As a cost-cutting measure, the firm shares its office with a saloon. A practice issue. A firm shares an office with a saloon. As Okuda sits an exception, he is constantly interrupted by staff and clients of the saloon as the two etapas share the waiting room. Kwaleso finally arrived and Okuda was ushered to meet her. He is directed to sit in a rickety chair and had to balance himself to avoid failing. That is another practice issue. The table separating him and his advocate is wobbly, and he is concerned that some file placed on it may fall down. So that is also a practice issue. Without any greeting or welcoming gesture, Kwaleso shouted at Okuda, informing that he opted not to attend the court to handle his matter as he declined to pay legal fees. So that is an ethical issue. The advocate shouted to him. The allegation was a shock to Okuda, who had promptly settled the invoices that he had been sent to him. Nonetheless, Kwaleso was not aware of the payments since she did not maintain the distinct and updated client records. That's another practice ethical issue. In addition, she maintains a single firm bank account in which all the transactions, including payments made by her clients, are made. And that's failed to take note of payments made by Koleswa. That's another ethical practice issue. It's only after Okudo insisted that he had deposit payments that he would actually provide his transaction slip, evidencing the deposit that Kaweso calmed down. Disgusted by the turn of events, Okudo demanded that he be given his file to enable him give an alternative legal representation. Get alternative legal representation. After leaving the farm, Okudo subsequently conducted an online search on Kareso at the Royal Society of Kenya website and realized that she did not even taken a practice certificate for the previous 3 years. Another ethical practice issue. There are so many ethical practice issues there. So you underline all of them if you are in an exam scenario for you to remember them. Because not all facts in an exam are relevant to the exams. Yeah. So question 1A, making reference to any relevant statutory provision. Discuss the prohibited conduct, omissions, or corrections that amount to a professional conduct rather than professional misconduct. So, what are the keywords here, Mr. Wakiaga? Question 1A, before even you answer.
The keywords are professional misconduct and the unprofessional conduct of an advocate. And
yes,
to expound on them, the major difference between the professional misconduct and the unprofessional conduct is that the professional misconduct may lead to a disciplinary action against the advocate. And unprofessional conduct may not lead to a disciplinary action against the advocate. Basically, they're just breach of manners by the advocate. Yes.
Yes. So now answer the question. Making reference to any relevant regulatory provision. Discuss prohibited conduct, omission, or correction amount to unprofessional conduct rather than professional misconduct. So you have given the
yes, I've given the difference. Now the omissions that would amount to unprofessional conduct, one of them would be failure to pick a phone call by the advocate when he was called by his client, by her client. I think the advocate is a lady, yeah? The second one is sharing the office reception with a salon. That's another act that would amount to unprofessional conduct. The other one is poor office furniture, where the client has to keep balancing himself on the table to avoid falling down. Another one is shouting at the client. Yeah, that also forms part of the unprofessional conduct, as that is regarded as bad manners. So far,
those are four.
Those are four.
Yeah.
I think those are the ones I'm able to pick from the question.
Yeah, so that is correct. Those are the unprofessional conduct. This question on unprofessional and professional conduct has never been tested since 2008. So this was the first question. It was tested. Projecting the question of the best and the best performing student got 20 marks. Yeah, it got everything in this question. So you explain. Yeah, question 1A. It is paragraphs to what amount to, yeah, you explained having the firm with office with the saloon. The UN basic principles conduct of lawyers requires that those with legal profession to conduct them with a standard of professionalism. Then you explain. Then failure to communicate and satisfactory performance. Yeah. Yeah, and satisfactory performance. He got to that. He said here the legal profession is regarded as highly and clients expect to best. Doing otherwise is to put the profession into disrepute. Coercion infringes on Okudo's right to quality services under Article 46. Yeah, of the Constitution, which is on consumer services, consumer rights. Shouting and uttering gesture. So yeah, so that is an answer well answered. I not need to belabor much. We go to the next question. B. If Okudo opts to file a suit in court for negligence, discuss the particular that he has to prove for Totaria's claim to succeed. 3 marks. So those are like 3 points.
Well, the first one
Mhm.
would be the failure. He will have to prove that the advocate did not have a practicing license,
Mhm.
at least for the past 3 years. And this one is actually this is the SOPEC one that requires advocates to hold a practicing license before they can practice. And failure to hold a practicing license for any particular year would actually be amount to professional misconduct, which is also related somehow to professional negligence. The second one is the advocate's account rules requires that an advocate separates the client's accounts and the office accounts. But this particular advocate had only one account where she banks everything.
Now, yes. The direction you are taking, it's I want you to read. You see, in exams, you must be able to read the question and understand it. So I want to read the question again slowly. If Okudo opts to file the court for negligence, discuss the particulars that are proof for the Totoria's claim to succeed.
Okay, now let me give it another approach. Tort has got elements. One,
tort of negligence.
Tort of negligence. There must be a duty. And this duty must be owed to the client. And this duty must have been breached. And after breaching the duty must have had an adverse effect on the client. There must have been some damage to the client. So this particular client was served abruptly without being informed that there's some summons which were coming from what I could read. And this was due to the failure of the advocate to inform him. So the advocate owed him a duty to inform him that this is where we've reached and you are expecting this kind of summons. That is one. And so there was the failure of the advocate to inform his client
that is the breach now.
That is the breach now.
So what were the damages?
The damages is that the client had the damage the client suffered is that he was not represented in court. Yes. So and, somehow yes.
And the interim orders were given in advance.
Yes. And again, the interim orders were given in advance and he was not informed about them. Yes.
Yeah.
And another duty that the advocate owed to this client
Mhm.
is a duty not to fail to represent the client because of failure to pay fees.
Mhm.
Yes, because much as the client had actually sorted out the invoice which he was served with, the advocate did not know that
Mhm.
some payment had been done, and
Yeah.
instead decided not to represent the client for failure
Mhm.
to pay the fee.
Mhm. Mhm.
So even if the client had not been paid the fee, the advocate breached that duty to represent the client.
Mhm.
Yes, those are so far what I'm able to pick out from the question.
Yeah, so I'm projecting the answer of the best performing student. So 1B, the answer is a duty of care, as you have explained. Breach of that duty, loss and damage, there must be adverse consequences. Breach of that is eviction of Okundo. Then there must be causation. Yeah, there must be a causal link between actions of the omission or collateral and the damage suffered. And remember, there is also something called foreseeable. It was foreseeable, you remember, in tort.
Yes, I can remember.
Yeah, all those things, you put the nini, you put all those elements there, and you are going to you are going to pass well. So this answer is repeated. It's asked many times in the past on negligence and the elements. The last time it was tested was in question 5, July 2015. And the answer on negligence, I've answered it substantially in the year 2008 to 2019 Q&A. Even some case laws are there. Yeah. So someone needs to look at that. Remember, the paper usually tells you must also have case law. If you have case law, they are good. And also, if you must, going forward, we will be also be looking at the relevant laws and the relevant case laws, because that is what the question paper questions at the page 1 usually ask you to that. Tells you answers must be supported by relevant case law and statutory provisions where required. So it's good to support your answer with statutory provisions and case law. So suppose Okudo institutes proceeding against Kaleswa, the advocate disciplinary to Ebino, and she is found guilty of professional misconduct. What punishments is she likely to be subjected to? 5 marks. So these are 5 points. So 5 kind of punishments.
Well, it is similar to what we had discussed before. The first I really don't know whether to call it a punishment, but the advocate would be admonished, meaning he would be reprimanded.
Yes.
That is 1. 2, he may be suspended from practice for a period of time, usually not exceeding 5 years.
Yeah.
The third one is that his name may be struck off the roll of advocates. The other one is that a fine may be imposed on the advocate. Yes, and given
this
that
fine is issue, and this is a very common question. And this fine is for how long? Fine is how much?
Is it 100,000? I'm not very sure.
Yeah, that is section 64. A very common question is asked almost in every exams. Someone needs to know in his or fingertips. We dealt with this question in April 2022. So the fine there, of course, is 1 million shillings, not exceeding.
Yes, And we proceed. Another thing that may happen, given that the client had paid some fee and at the same time picked the files to go and look for another advocate, the advocate may be forced to reimburse the payment, the fee that the client had already paid.
Yeah, not exceeding what?
Is it 5 million?
5 million. Very good. So paying the fine is to the disciplinary tribunal. That does not go to the advocate. That does not go to the client. Then the reimbursement is 5 million. So section 64 is very good to know. And that was the answer. Yeah, there's something here. The best and worst performing student says, which you can consider. So it discusses section 60, getting disbarred, advocate the tribunal with the power, strike out a payment of damages, fine, not exceeding. In fact, it's he said it's 100,000 and it's 1 million. Imprison. So he talks about imprisonment, which is not in the section 64 of the Advocates Act. You can consider in future. He says, he or she says, where the misconduct is found to be grave, the tribunal may transfer the matter to court where the advocate ran the risk of facing jail term for potential misconduct. Reframing this in another legal acceptable language is to say the case may be referred to the DCI for investigation. Remember, you cannot be taken to face criminal charges without DCI and the DPP. Yeah, and the other things you have talked about. Are we together?
Yes, we are together. So
anytime you are asked, this is a very common question. Anytime you are told about how the likely punishments of the advocates, that's another thing which you can add in your exams, and you add you get your 5 marks, or depending on the marks that is given in the question. So the more the marks, the more the writing. Question 1D. What is the rationale or justification of statutory and regulatory requirements that only persons qualified as advocates should provide legal services? So this is 8 marks. So this was a question that had carried a lot of marks in question 1. Yeah. So the keyword here is rationale, justification, statutory and regulatory requirements that only person qualified as advocate should provide legal services.
Yes, the rationale, just 1 minute. Yes. Yes, I think one of the rationale is that much as the unqualified advocates may still represent clients because they have the skills and every other thing, it is to protect the profession, where the advocates with practicing license do not end up competing with everyone in the industry. So I think that is one of the rationales that is put there to protect the profession in terms of regulation.
Qualified as advocates, not as one with the practicing certificate.
You know, for you to qualify. I'm getting you.
Yes. So in exams you must be very, unaona, every time you read a question, you underline
Yes.
the keyword. What is the rationale? You underline. What is the justification for of statutory and regulatory requirements for only a person qualifies as advocate should provide legal services. So
And
those
for
are
you
the
to
keywords.
qualify, yeah, for you to qualify as an advocate, you must be having a practicing license. Other than
Being an
the
advocate.
other than the professional qualification, for you to practice now as an advocate, you must be having a practicing license. And this is what I'm saying, that it is to protect the other advocates who have got practicing license from the competition of any other person who might be having the competence of representing clients. Yes.
Good. So this is one of the, of course, maybe this is one of the questions that you need a lot of writing. Yeah. So going back, and let's go at this question 1C. There is a case here, case law on disciplinary tribunal. If you have asked in an exam on 20th July 2020 in a disciplinary tribunal case number 79 of 2013, the advocate John Wachira Wambogo was struck off of the roll of advocates for what? For failure to render account of funds held by him on behalf of estate of John Bogu Wangoge, unlawful withholding of a state estate funds amounting to what? 27,484,708. Yeah, so he was told by the tribunal to pay the estate. He could not, he was strike off. So anytime you are asked about a question on an advocate or another punishment, advocate who was struck out, you can give this. And he's tried to appeal in the High Court and it failed. So you can look at the, disciplinary tribunal cost 79 of 2013. So he appealed to the High Court, and the opposite, which was Wambogo versus Disciplinary Tribunal of Royal Society of Kenya, Civil Appeal E20 of 2021. Yeah. So that was an addition on question 1C. So question 1D. So why is it there? What is the rationale, justification, and statutory regulatory requirements that only person qualified as advocates to provide legal services? Number one is to ensure professional competence and integrity. That is one. The law mandates that only persons qualified as an advocate provide legal, in order to ensure that those offering legal services possess the necessary education, training, and ethical grounding to serve public effectively. This helps maintain professionalism of the legal system. Yeah, relevant law, Advocates Act. Yeah, which gives Section 2 the definition of an advocate, and Section 9 on enrollment qualification to become an advocate. So case law, Republic versus Law Society of Kenya, and another ex parte kituo cha sheria 2013, EKRR. The court held that the Law Society of Kenya had the responsibility to regulate the practice of law in Kenya and protect the public from unqualified persons offering legal services. The court affirmed the importance of ensuring that only qualified advocates represent clients on maintaining legal standards. Another point, protection of public interest. By restricting the provision of legal services to qualified advocates, the law sets to protect the public from legal practitioners who don't have fully equipped to handle legal matters. This ensures that individuals and businesses receive competent, high-quality legal advice, which have legal significance on their rights, which have significant consequences on their rights, obligation, and well-being. So what is the relevant act of to rely on that? Section 34 of the Advocates Act, which talk about unqualified people. Section 34 of the Advocates Act, which talk about unqualified. Yeah. Unqualified person ought to prepare certain documents. 34. Yeah. So section 35 gives the penalties for unqualified. Penalties section that is that 1 4, and section 2 talks about 2 and 3 give the penalties. Any money received by an unqualified person can be recovered as civil debt. Yeah. Any person who shall be guilty of an offense. This is criminal. Section 34, 2 and 3. When I'm talking about this, I'm also answering any other question that may come in the future. That's talking about unqualified advocate. That's why I'm talking about this section. What is the other point? Ensuring ethical standards. So the requirement that only advocates provide legal services is also tried to maintain high ethical standards within the legal profession. So advocates are subjected to strict code. So we talk about SOPEC. Yeah. So Case Law Society of Kenya versus R 2015, EKR, the court emphasized the role of LSK in regulating conduct of advocates to ensure ethical standards are maintained. The case is illustrated the importance of adherence to the professional conduct and consequence of failing to meet this standard. Another point, preserving rule of law and justice. Allowing only qualified advocates to provide legal services ensure that the legal representations is fair and just, supports the proper administration of justice by ensuring those who represent others in legal matters understand the intricacies of law and judicial processes. This serves to safeguard rights of the individual. Yeah, will help maintain public trust in the legal system. Relevant statutory provision, of course, Article 46 on the consumer rights, and Article 46, 48 on access to justice. Yeah, because the Constitution requires consumers of reasonable quality. Yeah. Highest consumer rights. Yeah, that is one of the points I had gathered. I now go to the answer of the best performing student. He scored everything 20 out of 20. So let's see what he or she said. This question can come in another way in an exams. Why? Yeah, it can come in another way and you can answer. So, prevent commercialization. He says, number 1, prevent commercialization of the profession. Statutory and regulatory requirement of qualification the profession is dedicated to while service rather than profit. Having unqualified people profiting will provide opportunity to make money rather than improve services. Now that is point number 1. Abide by strict requirement. Restriction due to qualification limits the number of advocates and thus maintains professionalism. Another point number 3, regulated performance. Having only qualified person practicing performance in professional can be rated to high standards. Gun against losses to the public, which I've stated there in my point. Having unqualified people practicing will resist to mediocre services in the name of profits. People rely on such services and thereby incur losses. Number 5, ensure professional operations. Such restriction create boundaries in which professionalism can grow. The standards will improve. Point number 6. Protect the image of the profession. With only qualified people, the profession image will not be put at a disrepute. Now, point number 7. Qualification means quality services. This protects the right of consumer to get higher standard, attainable qualities. People who can actually be learned. This is in 946, which I've talked. His last point number 8, protect fiduciary duty of grants. Qualified advocates will uphold the duty of trust as circumstant. As such, the grant is protected from breaches of duty and consequent losses arising from conduct by unqualified advocates. Yeah, are we together?
Yes, we are together. And
So,
one thing
yeah,
I'm realizing,
yes,
I'm looking at the way these the best performed answered the question. It looks like the person is really not citing the statutory provisions.
And that's why they say,
what could be the effect of that?
No, there is no effect. They are saying ensure and answers must be supported by relevant case law and statutory provisions where required. Where required.
So that is the key term. Okay, I get it.
Where required. But here, yeah, where required. That is the key term,
Yes, that's the key term, yes.
Where required. Not all the question you use the statutory provision and case law where required. But when you remember and you put it, it gives you, it is an added advantage. Yeah? So to me, the person who was marking this paper for professional, this was very fair. It's rare to get someone who has gotten 20 out of 20, yeah?
Yes, it's what I've noticed that.
Yeah, you get people 18 from 18 going backwards. Even 19 I've never seen, So he must have been a very lucky person. 20 out of 20. We got to question 2, October 2022. Yeah. Let me see if I had another comment on question 1B. Yeah, this question has never been tested again. The way it is. So it was the first time it was being tested. And you needed to give a lot of points. 8 points, and you give a point and you explain. You give a point and you explain, as the best performing student is doing. Stating a point only will not add you good marks. So question 2. Wakili Jitegemea Kamili was admitted to the Door of Advocates on 23rd November 2021 by the first female Chief Justice of the Republic of Kenya, which of course is Martha Koome. He had very high hopes, planned to get a placement at prestigious law firm of Kulayot and Company Advocates when he had undertaken his pupillage program. He had served with the degree of diligence and commitment and we promised employment. So far, no ethical issue, no practice issues. Since admission, no favorable word on the prospect of job placement is forthcoming from the firm from other quarter. He has resolved to start his own law firm from effective from 1/1/2023. Although he did not have capital and does not see any forthcoming, he's moving forward, by faith, but plan to secretly borrow and invest in the law firm. Any funds, any current funds that come in fast. State at least 4 items he has to put in place, notwithstanding lack of capital, if it to avoid running into trouble with the Law Society of Kenya. So, what is this question asking you in another way, in another language?
I think the question is asking that for you to practice as an advocate, what are the mandatory requirements?
Not to practice as an advocate, to start a law firm.
Yes, to start a law firm.
To start a law firm. So, despite not having capital, so what are the other things that he does not, because his law firm effective from, it does not have capital, but anyways, we want to start a law firm. So what are the 4 requirements for you to start a law firm in Kenya, as per the Law Society of Kenya? Law Society of Kenya. So what are the requirements other than capital? This is what the question is asking you.
I think the first requirement is that first you must be having a practicing license. Because you are not allowed to start a law firm without a practicing certificate. So you've got to make sure that you are compliant as far as that is concerned.
So what is section of the law talks about practice certificate?
This is SOPEC 1, which requires all advocates practicing to have acquired a practicing certificate for the current year.
That is one. We need other 3.
Yes, the second one is for you to have a law firm, you need a physical office, and that physical office must be having an advocate. Because I remember there's a time that many advocates opened offices in some other towns, and when the Law Society of Kenya went round and found that those offices were being run by non-advocates, all of them were closed, were shut down. Yes. So the next, yes, you'll need a physical office. Let me think of the third one. Yes. Let me think of the third one and the fourth one.
So I stop.
You need, the law firm has another one. The law firm has to be registered, and there is there's a condition of registering it. When I read the advocates practice rules, that the law firm has to be in either your name
sole proprietor,
or the name of a former partner or a present partner in a law firm. So there's a particular way that name has to appear. Yes.
And you can open a sole proprietorship, partnership, or limited liability partnership. You register first as business name, partnership, LLP, and a business registration service before even you apply to the Law Society of Kenya.
Yes.
Another point. So another point, you must register the law firm with.
Yes, and another. Oh yes, and lastly, what I was thinking, you must have 2 sets of accounts. One with the client account, or one has to have the name client account, and the other one is the office account. You must have 2 sets of accounts separated and being operated differently.
Yes.
So those are some of the requirements that you'll have to put in place before you can start operating as a law firm.
That is under advocates clients account rules,
Yes.
Then another thing is professional indemnity. Very, very important. So you must have a professional indemnity at least for 1 year under the advocate indemnity rules. Another one, you must also another thing, you must of course have a PIN of the law firm. Remember, you pay income, eh?
Yes, yes.
Yeah. So you must be registered by KRA. So those are more than 4 points. You explain them. This is a question that you get maximum 4 points. The question was not done by the best performing student. Yeah, he did the other. This is the question he avoided. We go to the next question. B, should he receive proceed to secretary borrow the client's money? What are the sum of professional misconduct charges he is likely to face at advocate disciplinary tribunal? State at least 3 and explain the rationale for each. 6 marks.
The first one I can think of is the breach of fiduciary duty to the client, because you are not supposed to appropriate clients' money without their consent. And this person is going ahead to secretly borrow money from that client's account. So breach of that duty can actually amounts to professional misconduct. Breach of the fiduciary duty to the client's monies, to the client's funds. Yes.
So those are 2 points. You need another 2. Point number 2 is failure to pay client's money into the client's account. So according to advocate's account rules, an advocate must promptly deposit all client's money into the client account. By secretary borrowing such funds, the advocates fail to comply with this requirement, constituting a professional misconduct. Last point, disgraceful or dishonorable conduct. So section 60. Yeah, so I want to project section 60 of the Advocates Act. We see what it says. That is another charge you can be charged with. So, yeah. So, section 61 of the Advocates Act, a complaint against an advocate of professional misconduct with expression include discreditable or dishonorable conduct incompatible with the status of an advocate may be made to the tribunal by any person. So, another charge is disgraceful or dishonorable conduct, according to definition in section 61, by secretary borrowing client money undermines the dignity and ethical standards of the legal professional. Yeah, that is a dishonorable and disgraceful conduct. Are we together?
Yes, we are together.
So that is a question. Those are the charges. First time the question was tested, and if I said this question was done by the best performing student. Yeah, I think he found that he will not get he or she will not get enough answers. So we go to the last question of the day. Question 3, and I'm going to read. James Hotboy, JH, is a brilliant legal mind. He's currently working as a state counsel in the office of the Attorney General. He has a thriving legal practice where he practices on the side and is rolling in monies in the monies. He also the chairperson of legal advisory for Masaya Society, which is notorious for criticizing the government of the day. Masaya Society consistently sues the government, and JH, in his capacity as a legal advisor, takes up matters in the law firm, which he then attends to it in consult with the second in command, Kansogeshi Hot Girl. Discuss the ethical issues arising from the above scenario, making relevant to the relevant statutes. So the question is very direct, relevant statutes. So here, someone must talk about the law. What do you think? 6 marks.
I think first there is, let me read the question again. Let me just read it again.
Sawa. Thank you for reminding me.
The first ethical issue I can pick from this is the conflict of interest. Because one, the Law Society Code of Conduct provides that one advocate cannot represent 2 clients. But here is one person who is working as a counsel in the office of the Attorney General. At the same time, I can say actually working for another organization that is now suing, keeps on criticizing the government, and finally suing the government. So being on both sides, that is what is prohibited by the Law Society of Kenya Code of Conduct. And that amounts to conflict of interest. Another interest, another ethical issue I can pick out is the outside interest. Because this is one person who is also working at the Attorney General's office, but has got other interests outside, and the Code of Society, the Law Society of Kenya Code of Conduct requires that an advocate, because even at the Attorney General's office, he's still an advocate. An advocate, yes, an advocate can only do one thing at a time. Okay, you are much as you are allowed, you can be a director of another company, but you cannot be an executive director. Like this guy is actually involved in another business, which is doing at an executive level because he's directly involved in that business. So the outside interest, that is another conflict. That's another ethical issue that I can pick from this particular question. Another one I can pick out is the honesty and integrity. And this one, the legal foundation is I think the chapter 6 of the Constitution that talks about leadership and integrity, where when you are serving the government, you need to serve with honesty. But this person is actually serving the government with all the other interests outside, meaning he's not honest enough with the employer who is the government. Yes.
Good. So those are like 3 points you have given. You have tried. Yeah. So, and you have done well. So if a question comes like this, let me project I've removed the question, let me project it. So this question is on advocates who join the public service.
Yes.
So being a state council, any advocate who is in public service, in the cost in public service, whether it's in the attorney general office, county, everywhere, leave alone judges and magistrates, leave those alone. Those are state officers. So if you are told to talk about relevant statutory and relevant statutory provisions, you start with the Constitution. What are the ethical issues? So the Constitution, you talk about the public service. So you go on the chapter on public service, which is Article 232. I want to project it. So values and principles of the public service. Yeah. So what are the values and principles of public service? Remember, they are public officers. So the values and principles of public service include high standards of professional ethics. 232.1.
Put it up. It's not. It's
Now?
not projecting. Still not yet.
Now?
Is still not there. I wish you drop it, then you put it up again.
So what is it projecting? So the first one is a public officer is a civil servant.
Yes, yes.
Yeah, so you must know what the definition of the difference between a public officer and state officer. Do you know the difference?
Not precisely. But
So
what I know, yes. I only wanted to compare it with the courts where the magistrates are public officers. I mean, where the judges are they public officers or not? Okay, there's a difference between
they are.
They're public
I want
officers.
to give you the
Yes. Okay.
I want to give you the difference.
Okay.
So the definition of public officer that is Article 260 of the Constitution. You are going to look at it. So a public officer means any state officer or any other person other than state officer who holds a public office. Then public service means the collective or individuals that other than the state officer performing a function with a state organ. So state officers, a public officer is state officers and civil servant. Unaona? But state officer is of course state officer is also defined in the Constitution. State officer means a person who is holding a state office. And what is a state office? And what is a state office? President, deputy president, cabinet secretary, member of parliament, judges and magistrates, members of a commission, holder of independent office on chapter 15, applies member of county assembly, governor, deputy governor, attorney general, DPP secretary to the cabinet, PS, chief of defense staff, commander of the service of the Kenya Defense Forces, director general of national intelligence, inspector general, other offices that is designated as state office by a national legislation. Unaona?
Yes, I'm getting you.
So public officers are state officers and people who work in the civil servant, but state officers, of course, are defined.
Yes.
So what is the after knowing who a public officer is, then you talk about what guides them is the public service, because all of them work in the public service.
Yes.
So of course you talk about chapter 6 of the Constitution, which we discussed last time. Then you come to Article 232. Values and principles of public service. What are the values and principles of public service? Number one, high standard of professional ethics. So relevant to our question, So higher standards of professional ethics. The other values you are going to read there. So that is one of the infringement that you had infringed this question. So you infringed chapter 6 of the Constitution, as you said, and Article 232 on the values and principles of the Constitution. So another point is the Public Service Values and Principles Act. You are going to look at it, some provisions there, which of course elaborated more on Article 232. Public Officers Ethics Act and Code of Conduct is another one. You can look at public officers because I think, public officer. I can project it. See if it will be projected. You can see.
No, it's not there. I think there's a problem from your end. Yes.
Yeah. No problem. So what are the infringement here? Performance, section 9, professionalism. It talks about professionalism, rule of law. That is section 10. No proper enrichment. You can look at it. Conflict of interest, section 12. Yeah. Conduct of public affairs, section 20. You can look at it. Another thing you can talk about is Anti-Corruption and Economic Crimes Act. So individuals in public service, when they abuse office, it's called engaging and undermining public trust, which you can be charged with a criminal offense. Yeah, now we go to the State Council's office of the, remember this is a State Council in the Attorney General office. So the last act we are going to look at is the Office of the Attorney General Act. Which is on your screen. Let me see if it is projecting. If it is not.
No, it's not projecting.
Okay, don't worry. I'm going to fix for the next video. So Office of the Attorney General Act, relevant sections. Section 10, Attorney General, Solicitor General, and State Council shall not engage in other gainful employment. That is the relevant section. Another section is code of conduct. A state council appointed under section 21 shall subscribe to himself code of conduct and set out in the schedule. So the code of conduct for state councils is in the schedule to the Office of the Attorney General Act, which talks about, relevant to our question, honesty, loyalty, and dedication. That is Rule 2. Responsibility, honesty, quality services, fairness and diligent integrity, rule of law and administration of 15 personal conduct, 16 conflict of interest. And when you give those points, you have answered that question given more than enough. Are we together?
Yes, we are together.
Good. So, yeah, you can look at the answers of the best performing student. He scored 8 marks. He did the question at the second question. Ethical issues arising, conflicts of interest, which I don't need to repeat. Fiduciary duty, confidentiality, you have talked about it. Yeah, this question, he talks about, yeah. We go to the last question of the day. And I'm going to read it. Question 3B. Which is 4 marks. Lucy Kimani, kijana is a wealthy young billionaire. Lucy Kijana is a wealthy young billionaire who recently inherited 2 vast properties in the Rife suburbs of Nairobi from his deceased Thankwood father. Unfortunately, Banky Big is suing him. Banky Big claims that his father charged the 2 properties to aid in exchange of massive loan, of which loan is still outstanding. Banky Big wants its money back. Kijana approached Advocate Mujaja MM and enters into an agreement for legal services. Advocate MM assures him that he will be able to represent him and keep abreast of all proceedings. He tells Luke Kijana to rest easy because he has never lost a case. He enters appearance in the matter, and despite being served, he neither makes any court appearance nor file any submission. So that is first ethical issue. Since the suit is undefended, judgment is rendered in favor of the bank. Lucy Kijana is in utter shock when he's informed that the concessionaires are at his properties waiving a court order. He attempts to reach MM futile. Another ethical issue. His shock escalates further when he's reliably informed that Advocate M drew the charge documents from Banky Big and is still advocate for the bank uses for its conveyancing transactions. Another ethical practice issue. Lucy Kijana has come to you as a newly admitted advocate with great passion in professional ethics and practice. Explain to Lucy Kijana the ethical issues that faced Advocate MM when the lucky Kijana approached Advocate MM to represent him against Banky Big.
The first ethical issue that I would pick is just one that we've spoken about a number of times. This one of conflict of interest.
Yes.
Yes, and where the advocate represents both parties.
Mhm.
And the Law Society of Kenya Code of Conduct actually prohibits an advocate from representing two parties without their consent.
Mhm.
Two is the question of honesty and integrity,
Mhm.
where he represents two parties and without informing the second client that is actually representing the bank. The
Mhm.
question of integrity comes in there, and
Mhm.
honesty. Yes.
Mhm. Mhm. Yeah.
And there's also the question of client privilege
Yes.
and confidentiality.
Yes. That is section what?
Is it section 34?
134 of the
What?
Evidence Act.
Yes, 134 of the Evidence Act, yes.
Mm-hmm. Yeah, you explain and you are going to get your answer. So, conflict of interest, duty for honesty and integrity, confidentiality. These are very many repeated questions. So you need to understand very much on your SOPEC, the code of conduct, so that you explain well. And you get your 4 marks. And this is a question that was repeated from April 2022. Yeah, so the next questions, the next part 2 of this part of October 2022, we are going to tackle question 4, 5, and 6. Yeah, the next video. Thank you very much for watching. Subscribe to the channel.